money.
I'm going to call Kamal Cipollone.
Mr. Chair, I want to speak to the purpose of this bill as well and just cite a few issues that were raised by submitters during the process. Mr. Chair, this particular bill and what it is attempting to do really does strike to kind of the emotional side of everyone in this House and the general public, and it's really important that we do consider this rationally, that we do consider the evidence that is in front of us. So we did have to give this a lot of thought before we could confirm that we would support it at this stage, Mr. Chair, and one of the reasons that we have decided that we will support it is because of the support that we do think we have with my colleague Jacinda Ardern's SOP, which will change the name of the bill to the Child Protection, Child Sex Offender Government Agency Registration Bill. We want to make it really clear that this is about government agencies sharing information, Mr. Chair, rather than this being a public register that records the names and provides information about sex offenders, Mr. Chair. We had a number of submissions that pointed out the evidence internationally which proves that actually public registers do not work, Mr. Chair. They may give the general public a sense of security, whether that is a valid sense of security is another question, but the fact is, Mr. Chair, that the international evidence we were presented with shows that a public register does not work with regards to reducing the chances of reoffending by sex offenders. So therefore, Mr. Chair, a public register would not make our children, our community any safer. Mr. Chair, the purpose, as I said, is an admirable one and one that we do respect, but I have to bring up that a number of the agencies and individuals that submitted on this bill did say, and I'm talking about agencies and individuals who actually work on, in some instances, with the victims of sexual offences and with some instances the actual sexual offenders. The majority of those that were in that position actually reported that they didn't think that a register would change anything at all or in any significant way, Mr. Chair. They were concerned, many of them, that this is a large amount of money. We're talking about with $146 million to implement this register over 10 years, and they were concerned, Mr. Chair, that this money could be spent in places that would better address the needs of victims or actually create more of a secure environment so that we are less likely to have as many victims, or we're able to reduce the number of victims of sexual offences, Mr. Chair. So it's really important to note that, because those really are the experts that are on a day-to-day basis working with the victims of sexual offending or the sexual offenders. And for them to say that this was not the best use of money, that really needs to be noted, Mr. Chair. Mr. Chair, we have real concerns around the issues of false security. People seem to think that if you do have a register and you know who the sexual offenders are, then they will be safe. But the reality is, Mr. Chair, and we saw this evidence presented at the Select Committee as well, that unfortunately the reality is that the majority of people who will sexually offend against children are actually close family and friends. So we can't protect them, Mr. Chair, through this particular piece of legislation, because most of them will be unknown to the justice system. And so I would hate to think that this would provide a sense of security for the public out there, because the reality is that we all need to be aware of the fact that quite often, more often than not, the sexual offending is actually happening in our own homes and in our own communities, and not by people who have been convicted of sexual offences in the past. So it's really important to note that. I wanted to refer to one of the submissions that were made, and that was a submission made by the Salvation Army. And I'm sure, you know, all of us in the House do respect the opinions of the Salvation Army and the fact that they do come with evidence-based views around these types of issues. And the Salvation Army refers to clause 43 in the bill, and talks about the flawed conceptions of public safety. So the Salvation Army submitted that a register without sufficient safeguards on its use by the public can actually create conditions that may lead to reoffending. It states that currently, Mr Chair, currently in clause 43, the bill allows for disclosure of information to a third party if the Commissioner believes on reasonable grounds that the offender poses a threat to the life, welfare or sexual safety of a particular child or particular children. And I don't really feel like we got to the bottom of that particular issue in Select Committee. There were discussions about who the third party might be, and I think at one point it was discussed that boards of trustees might be the third party that the information could be released to if they thought that someone posed a threat. And of course, Mr Chair, we can understand the rationale for that, but then at the end of the day, if this is not intended to be a public register, I guess how does the Minister anticipate that that information won't go any further, given that the boards of trustees are actually members of the community, parents of the children at the school? It's hard to see how that information could be confined to just that board of trustees and not shared more widely within the community. And I'm raising that because of the fact that the government has committed to the fact that this will not be a public register. So I guess just thinking that through, how do we stop that happening? I think someone brought up in Select Committee that the third party could be perhaps a church minister if there was concerns that a sexual offender that had been released may pose a threat to their congregation or the children in their congregation. So I guess how does that information then get passed on? How are those decisions made about who appropriate third parties are? And I guess it would be really good to get some more examples from the Minister about who appropriate third parties would be with respect to that particular clause. Mr Chair, I just want to go back to I've got lots to say, just kind of lost my place here. The fact that we have had a very broad-ranging discussion in Select Committee about whether or not this should be this register should be made public, and I just want to contrast the SOP that Jacinda Ardern has put in with the SOP that has been put in from Derek Ball. So I know that Derek Ball and New Zealand First is trying to make this register public. Ours is trying to confirm that this is actually a government agency registration bill and not for the public. So there is a clear difference of opinion here, Mr Chair. It will be very interesting to hear from the other members of the other political parties what their thoughts are on that particular issue. Mr Chair, going back to the cost of setting up the register, we did feel that they are disproportionate to the evidence in terms of benefit. As I stated, several submitters working in the area cited serious underfunding of proven strategies for curbing sexual offending and struggled to reconcile this underfunding with the investment of $146 million into a register. For those that haven't been part of the Select Committee process, it would be interesting to hear from the Minister how $146 million will be spent and what effect the government anticipates in terms of the actual impact that will have on sexual offending or re-offending by these sex offenders. Mr Chair, it's important to note that submitters articulated the need for government to place a higher emphasis on investing in research and evaluation of other means of reducing offending, such as specialist offender treatment, primary preventative education, as well as working with children, young people, families and communities about recognising harmful behaviour. And all of those things, Mr Chair, are areas that we would have preferred $146 million to be spent on rather than on a register. Hence why today we are here saying that we are supporting this bill, but with some major reservations, that being one of them, where money could be best spent. What does the evidence say with regards to how we stop sexual offenders re-offending? How do we keep our children safe from sexual offences, Mr Chair? It's important, we understand, to manage any risks to children in the community posed by convicted child sex offenders who have come to the end of their sentences or are serving non-custodial sentences, and we do think that this bill will allow for the tracking of convicted child sex offenders in the community to be used as a tool to try and prevent re-offending, but it's by far definitely not, Mr Chair, a silver bullet to the issues that we are talking about, and definitely not going to resolve the issues of sexual offences against children. It is one tool. It will maybe do a little bit, and it may give the community a sense of security, but there's a lot more that needs to be done, Mr Chair.
The Honourable Anne Tolley.
Ms